Hi, this is Patrick Conroy, and this is Chapter 8, Legal Environment of Business. Today we're going to talk about property, real property, personal property, and intellectual property. First, let's talk about real property. Real property, real estate. In Louisiana, the legal term is often immovable, something that cannot be moved. It's land and everything permanently attached to it. Now, how does the land ownership work? Well, you own everything on the surface, everything in the air to the top of the sky. Water rights, the water below and to the side. Mineral rights, if there's minerals under the ground, you own them. Now, in practical terms, they're often what are called easements. We'll cover those a little bit more, and that's what allows planes to fly over your house, even though you own the air above your house. Okay. Fee simple absolute. What that means is that you own the land, and you can do anything you want with it. Providing zoning allows it. And you can devise a will for your heirs to get it upon your death. So that's called a fee simple absolute. Now, the terms in Louisiana are different because of our French heritage. Now, a conditional estate, it's like a fee simple absolute, except the interest will terminate on occurrence or non-occurrence of a specified condition. You can have this house until your children are 18. That's conditional estate. Often it's more that someone will own it until they pass away, and then it'll go to somebody else the original owner designates. That's a conditional estate. In Louisiana, those are called life estates, or in Louisiana, that's still a conditional estate. A life estate is granted for the lifetime of an individual. It's a type of conditional estate, but the right to own it terminates upon life estate's holder's death, and property will pass to another party designated by a regional grantor. The most common way this comes up is I'm married, I pass away, my spouse has a life estate on our property until she passes, then it goes to the heirs. In Louisiana, this is called a usufruct. You have the use and the fructus, but not the abusus, which is what means you can't sell it. A future interest is the person's right to property ownership and possession in the future. Once my spouse dies, other people will get it. A leasehold, right to possess but not own the property for a stipulated period of time. You rent it, basically. You're a lessee. Now, these are some of the things that are going to affect your land ownership. An easement. It's a irrevocable right to use some part of another's land for a specific purpose without taking anything from the land. Common example is utility easement. Or as I said, the easement over your house for airplanes to fly, or utility cords to fly, to go across your property. Sometimes it can be things like a driveway. We won't really go too much into that, but it can be. The profit is the right to enter another's land and take part of the land or take away a product from it. So for instance, you might have the right to harvest someone's land, trees are immovables, but you have an agreement where you can come in and harvest the timber. And the license is a temporary revocable right to use another's property. Theater ticket. That gives you admittance into the theater, but you don't own the theater and you have to leave after the movie. Transfer of real property. requires preparation and signing of a deed. The delivery of the deed to the grantee with the intent of transferring ownership to the grantee. If I ask you to hold on to my deed, it doesn't mean that I've given you ownership. I've just asked you to hold on to the deed. Even though I've given, you have it in your hand, I never intended to transfer ownership. Acceptance, the grantee's expression of intent to possess and own the property. And recording, you have to file with the county or parish where the land is located. Involuntary transfers, adverse possession. This sounds really fun, but it really doesn't happen all that much. When a person openly treats real property as his or her own without protest or getting permission from the real owner for statutorily established period of time, ownership switches to that person. So often this can be a fence was placed in the wrong place. And for 20 years, everyone's assumed that that was the property line. Well, that time has passed and someone realizes, hey, I actually have more. Well, adverse possession would have come in and taken place and the property line would have actually been moved. And the other person owns that. It has to be for about 20 years in Louisiana. Condemnation, the government requires ownership of private property for public use for just compensation over the protest of the property owner. You don't want to sell, but the city wants to build a new airport right where your house is. They can come in and condemn it. This often comes up and is challenged in the courts. And they really look to see what is the public purpose and is this an overriding public use or not? A lot of stadium cases. The government comes in and condemns land for a stadium. And people are like, hey, that was my business. I don't want to sell that. So that's condemnation. Personal property. Okay, we're done with real estate immovables. Got the brief overview. Personal property. All property that is not land or not permanently affixed to land. Types of tangible. Well, those are things you can touch. Your car, your purse, your clothes, all those things. The furniture in your house. Sometimes you have to look to see if, like, a chandelier in your house might be considered part of the real estate rather than a personal item. The wiring is all done and it's permanently attached. Then it goes from a personal property to real estate. An intangible property is something that you can't really touch, like your stock investments or your bank accounts. You can get the money out, but it's not really, it's just numbers on your computer screen until you do something with it. That's an intangible. Voluntary transfer of property, kind of two ways. Purchase it, and the buyer gets consideration to the seller in exchange for title to the property. Or you can be done by gift. Donee gives no consideration to donor in exchange for title to property. You can give away property. You need to be careful. There might be a tax liability if you give away something really valuable. In order to be a valid gift, there has to be delivery. There has to be a donative intent. I meant to give it to you, not lend it to you. The other person has to accept it. Involuntary transfer of personal property. Abandoned property. Property the owner has discarded. Lost property. Property the owner has unknowingly or accidentally left somewhere, which is different from mislaid property, where the owner put it somewhere and then just forgot where they put it. That's involuntary transfer of personal property. All of those things can transfer ownership, even though the person might not have wanted to transfer ownership. Though with lost property and mislaid property, they're usually things you have to do as far as reporting it found and things like that. Okay, another big property, we're switching out of real estate and personal property to intellectual property. Okay, and that is property that comes from creativity. The painting you make, the book you write, the movie you direct, all of those are types of intellectual property. And they can include trademarks, trade dress, which is similar to trademarks, but it has more to do with how, if you go into a Wendy's, every Wendy's looks the same. That's their trade dress. Copyrights, patents, and trade secrets. So we're going to go through these, but what's a trademark? It's a distinctive mark, word, design, picture, or arrangement used by the seller in conjunction with the product, intending to cause consumer to identify the product with the producer. For a trademark to work, it has to be registered with the U.S. Patent and Trademark Office, and it must be renewed every 5 to 6 years after the initial renewal. Oh, every 10 years. So you have to do it within 5 or 6 years the first time, then 10 years each time after that. Type of, what you can get if someone is using your trademark: money damages, an injunction. So let's say I have Conroy popcorn. I trademark that term, Conroy popcorn. Then no one else can, even someone else named Conroy can't use that name. One of the most recent big cases in this area was the Renduzas, fighting over the use of the name Renduza and who could use it and who couldn't. Trade dress refers to the overall appearance and image of a product. And it's entitled to the same protection as a trademark. And the main focus of trademark infringement cases, whether it's likely the consumer confusion in the comparison of the two products. You open your restaurant and you call it Good Eats Eating. Someone else opens it and you decorate it with blue and white tablecloths, and you dress your people all in a certain way. Someone else opens a restaurant called Trade Dress, and it looks the same, and the people are wearing the same uniforms. So that might confuse people, and they might think that they're getting your product when they're getting it from somebody else. So you have protection in that. Copyright. This is the expression of a creative idea. Examples of copyrighted material include books, periodicals, music, works of art, computer programs, all sorts of things. So it's fixed, it's original, and it's creative. And the remedies for copyright infringement can be money damages and injunctions. So you might hear a musician saying such and such stole my song. What they're saying is they have the copyright on something in that song because they did it first. The fair use doctrine provides that a portion of copyrighted work may be reproduced for purposes of criticism, comment, news, reporting, teaching, scholarship, and research. That means we could discuss a CNN article, even though it's copyrighted CNN in this class. Factors. What is the purpose and character of the use? including whether use is of commercial nature or for nonprofit educational purposes. That's what I meant, like we could discuss it in this class. I could not go out and sell the CNN article. The nature of the copyrighted work, an amount and substantial the abortion use in relationship to copyrighted work as a whole. Well, that means that if I copyright a page, if I copy a page from a book and hand it out in class, that's okay. If I copy the whole chapter and give it out to the class, that might not be okay. If I copy the whole book and give it to the class, no. And part of that is the effective use of potential market for or value of copyrighted work. If I gave you these copies, there'd be no reason for you to buy the book. That's why the writer has been damaged. They're owed money damages. A patent. A patent protects product, process, invention, machine, or plant that is useful, novel, and non-obvious. Thus is 20 years. So you create a new drug that cures cancer. You patent it. Well, that'll last for 20 years, and no one else can use that same formula to create a similar medication. If they invented a whole different medication with different chemicals, yes, so they couldn't copy yours and sell it. The America Invents Acts of 2011. Now you have to be the first to file a patent. So if you have cured that cancer, you better file that patent before anyone else finds out about it. Or even if someone else is working on it. And it changes the rules for what is patentable, and it changed the re-examination process, and it made it easier for small businesses to apply for patents. A trade secret is a process, product, method, or operation or compilation of information that gives a business person an advantage over his or her competitor. Trade secrets are often used frequently as an alternative to patent protection. McDonald's spends huge amounts of money researching possible locations. If Subway came along and took that research for their own uses, that would be considered a trade secret. Or even how McDonald's determines what will be a profitable place. That is a trade secret. And so if someone can't go working for McDonald's and say, hey, I know all the trade secrets. I will come work for you, and we can use those trade secrets. Cannot do that. Remedies, money, injunction, you stop them from doing what they're doing. That the owner has to prove that the trade secret existed and the defendant acquired trade secret through unlawful means. McDonald's posted on the internet how they determine which sites are going to be the most profitable. Then they acquire it through lawful means so they can use it. And they use the defendant's trade secret without plaintiff's permission. Okay, that's it for property. Go ahead and read the chapter, do the smart book assignment, and take the quiz. Not really too hard. I'm sure you'll do fine. Thank you and see you next time.